Well, seats had been sold out for a week for today's Sydney Mining Club lunch. Such was the anticipation. For the first time, the miners at the centre of the ICAC inquiry into corruption around mining tenements in the Hunter Valley have spoken out, with the backing of the Mining Club founder.
Those companies, their shareholders, had those assets stripped without any process, without any due process. I mean, if it was done in sort of thing Hugo Chavez did in Venezuela.
Well, it's a complex yarn about how a minister in the state government favoured the interests of Eddie Obeid and his family, and to what extent, if any, the directors of the mining companies involved were part of the action. ICAC found politicians Ian McDonald and Eddie Obeid, together with Cascade Coal directors Travis Duncan, John McGuigan, Richard Poole and John Atkinson, engaged in corrupt conduct to develop coal mines in New South Wales' Bylong Valley. They were found to have concealed the involvement of the Obeid family from state government officials. The state government took back the mining leases from Cascade, and also a licence that listed miner New Coal had inherited from another company that ICAC found was so tainted by corruption that it should be cancelled. But everything changed with a High Court verdict that went against ICAC and its investigation into high-profile State Prosecutor Margaret Cunneen. In a ruling, ICAC had overreached its powers, previous findings were suddenly thrown into doubt, and the mining businessmen involved began fighting through the courts to have them overturned, get their licences back, plus damages and legal costs. Well, Mike Baird's government rushed through retrospective legislation to shore up ICAC last month. The corruption findings still stand, and the courts have backed the revoking of the coal licences. It's all subject to appeal, though, with a High Court challenge being fast-tracked. Margaret Cunneen was sitting next to John McGuigan at today's event. I sat down with Cascade Coal Director John McGuigan and New Coal Chairman Galt just after the Mining Club event. John McGuigan, Galt, thank you very much for joining me.
Pleasure, thank you.
As of the 6th of May, the High Court challenge was defeated. ICAC's original findings have been reinstated. Why do you say there's a sovereign risk, John?
Look, sovereign risk arises when a government takes action which imperils investment conditions and makes those basic ground rules that govern investments imperilled. And I think what has happened here is that the New South Wales government, by its actions, have taken proprietary assets from innocent companies, even by the dint of ICAC's own findings.
And Gordon, you suggest that actually this is actually impacting internationally.
Oh, it's definitely impacting internationally. Just to elaborate more on sovereign risk, Australia's got lots of free trade agreements. We're about to sign a TPP with 12 countries, biggest free trade agreement in the world. Embedded in there is the principle that you can't expropriate without compensation. This is a fundamental sovereign risk issue acknowledged by all the nations of the world.
I guess from the New South Wales government's point of view, sovereign risk is more about corruption between government and directors in the private sector, and something they've got to sort out. Now, Ian McDonald, the minister, was found to be corrupt. John, do you think that directors like Trevor Duncan and indeed John Maitland in the case of New Coal are not corrupt?
Well, I think by the High Court finding in the Cunneen case, they are clearly not corrupt.
Well, Margaret Cunneen's spectacular victory has changed things a lot, hasn't it?
Well, what it has done is really codified what many people have understood the law to always be, that the ICAC legislation concerns itself with the corruption of public officials, and private citizens get involved or get caught up in it if their actions go to the corruption of those officials. Clearly, speaking from a Cascade perspective, there was no action which impacted on any government official.
Let's go, John, to the two issues that ICAC was concerned with about yourself, and I'm quoting from the Jasper findings. It's clear that John McGuigan knew that the Obeids were also behind the nominee company that would hold a 25% interest in the joint venture. Can I ask you straight, did you effectively run the negotiation with Moses Obeid on the 25%?
I was involved in all negotiations. As I said today, the negotiations were about ensuring we had access to the land, and that that involved two elements. One was a right over land, and the other was an interest, an equitable interest, in a prospective venture.
But it's a who knew what when, of course, and I guess ICAC's allegation or finding that as at June 2009, you knew that Buffalo Resources was a corporate entity majority owned and controlled by the Obeid family.
Well, that clearly was the ICAC finding. Frankly, in the context of the corruption findings, which were found against me, that's a so what issue. It had nothing to do with the findings.
And on the issue of that, ICAC also found that you failed to alert White Energy, or the board, as to the previous presence of the Obeids in Cascade, and as a board member of both companies, you should have done that.
Well, look, I gave evidence to the contrary to ICAC, but quite apart from that, we, of course, did have a judicial review appeal. We went to the Supreme Court of New South Wales, where we did not win every point. We'll go to the full court. But on that issue of the discharge of duties of a director, and whether the Cascade directors, who were also involved with White Energy, properly discharged their duties towards White Energy, the judge was very clear, and the answer was that they did.
So you disagree with ICAC's findings? Absolutely. Yeah. I think...
well, sorry, not only do I disagree,
yes,
the Supreme Court disagrees.
I think it was agreed to pay the Obeids $60 million to get out of Cascade. Only $30 million has been paid. Do you still owe?
No, we don't. We do not.
So there's no legislation, there's no legal action there?
No,
right.
none at all.
Okay. Turning to Newcale, Jasper Gordon, the ICAC finding, again it's a who knew what when, I suppose. The ICAC finding was for corruption against both former Minister MacDonald, but also Messrs Ransley, Poole and Chester. Now, these were people who were involved on the original Doyle's Creek company.
2006 to 2008.
Now, they were also on the New Coal board.
Well, two of them joined the New Coal board because when we bought the company for shares, they were significant shareholders by the fact that they accepted shares and they had significant escrows. So it's very logical and usual for large shareholders to have a representative on a board. We didn't know there was anything at issue, so we were quite happy to have them on the board.
Can you... is it believable that the New Coal board was blindsided, given the fact that some of these directors knew well about and were found by ICAC to be corrupt, and also that the media in early 2010 were raising questions?
I'm sorry, we bought the company by early 2010. So after, you're talking about something that happened after, and it didn't actually happen until long after we'd bought the company.
And the knowledge of those directors who were on both boards didn't filter through to the rest of the board?
Well, I start every board meeting with, do any directors have any issues or conflicts to declare or any matters that should be reported to the company? So every board meeting, all our minutes are available. None of them were taken by ICAC. They weren't interested.
So do you have concerns with those existing those directors who were previously on the board of Doyle Creek?
Look, it's irrelevant to me. We bought as a third party. We paid good money as a third party. We couldn't go to the minister and ask him if he was corrupt. So we did what we could and we went on with life. We're an honest business trying to do something.
John McGuigan, you have actually raised some very serious allegations now about the relationship between ICAC, Commissioner Ip, and the government. I mean, it sounds as though you're suggesting that they were colluding with each other over this inquiry.
Well, they were certainly communicating. There was, of course, Tiki, a challenge that was ultimately ended up in the High Court, undertaken by one of the Cascade shareholders, which addressed the question of apprehended bias on the part of Commissioner Ip. During those proceedings, it became very clear that there were extensive communications between Premier O'Farrell, between his Chief of Staff, between other ministers and the senior bureaucrats in the relevant departments.
And on that same thing, if I can butt in, we've been trying for years, more than 2 years, under freedom of information, because New Coal actually doesn't have any standing in all these inquiries. That's the only access. We've been completely stonewalled by the government on every occasion. We can't get any information as to what communications there were between the Commission and the Premier.
Where to from here, gentlemen, for you both?
Well, look, I think it's quite clear. In our case, and I think in New Coal's case, there are legal avenues. Unfortunately, we've seen, as a result of the Margaret Cunneen situation, that if the result of going to the High Court, whose main job it is to determine the ambit and scope of relevant legislation, if the result is the result that this government doesn't like, then you have to question the relevance of doing that. But I continue to believe that that is highly relevant and the determination of the courts will ultimately prevail. So that's number one. Number two, I think there is a need for an inquiry into the recent ICAC inquiries as to the manner of conduct, the approach that's been taken, and I note, of course, that Gordon has taken a similar approach.
Margaret Cunneen was here today, obviously. Will she be assisting either of you in your causes?
Look, I think Margaret Cunneen has been an incredibly gutsy lady to deal with matters the way she has, and as I understand it, her expertise lies in other areas.
And I would say I've met her, I've had a couple of chats to her, and that's the end of it. So there's no assistance or anything like that happening as far as we're concerned. We believe that the Parliament has actually been misled in passing the Mining Amendment Act. The way it was done, all of the lead up to it, clearly the law was being written at the same time the government was supposedly considering our show cause submission. Now, I think the two of those are fundamentally opposed. So the Parliament then has had it rammed through in a day, and one parliamentarian subsequently, the member for Cessnock, has stood up and said, we did the wrong thing. So far, none of the others have, but I think when they find out how much they've been misled, there'll be a cacophony of politicians saying that they do have more ethics and more morals than where they've been led by this.
And
Can I just add to
yes.
that in the Cascade case, the basis of the expropriation legislation was premised on a finding that was never made. Never made.
That being?
That the grant of these licences was so tainted by corruption that the rights should be taken away from innocent parties. What happened in our ICAC findings was that they specifically, on the part of ICAC, endorsed the process and the procedures which we relied upon in terms of the grant.
John McGuigan, you've also got the ACCC after you now for alleged cartel behaviour.
Correct.
And what do you think is going to be the likely outcome of that? What's your response to it?
Well, look, it's sub judice, and the likely response is that which you would undoubtedly expect to hear. It will be vigorously defended.
John McGuigan, Gordon Galt, thank you very much for joining me.
Thank you very much.